Using the Electoral Disqualification of Convicted Prisoners Amendment Bill. And I don't think any sort of mock anger, mock outrage on that side of the House will cut any mustard on this side of the House. We know why this bill is being introduced. It's called dog whistle politics. There is nothing worse in this House than to see matters of substance raised in a debate on an amendment to an electoral law. To use that as my strongest possible objection, to use the electoral law to argue this dog whistle position on attacking people who are in prison at a particular time. Now, this has got a very, very strong history to it, and it was the subject of consideration in 1986 by the Royal Commission into our electoral system. And during the Royal Commission consideration of our electoral system, they raised this issue about the fact that no prisoner could vote when they were in jail on election day. And that's how the law applied at that particular time. And so that was the concern that the Royal Commission addressed, and actually they were ahead of their time because they were several years ahead of the passage of the New Zealand Bill of Rights Act. And the New Zealand Bill of Rights Act is what leads to the Crown Law Office actually writing the opinion that member seems to think that Chris Finlayson has written all by himself, but that's by the by. That's by the by. The point that I'm making is that the Royal Commission, who considered this issue at depth and did not have the benefit of New Zealand being subject to the New Zealand Bill of Rights Act, actually decided that this was not correct to actually say to people that you haven't got the right to vote if you are in prison on election day. Now, what happened after that was, of course, the question was raised in 1993 when changes to the Electoral Act were being proposed, and in fact the Solicitor General at that time, John McGrath, was advising the government that the question of denying all prisoners the right to vote was actually a breach of the New Zealand Bill of Rights Act by that stage. And so the government of the day, a national government under a very good Minister of Justice, Doug Graham, was actually considering this whole question in the light of our obligations under the New Zealand Bill of Rights Act. And what it was said was that imposing a limitation across the board on these rights could not be justified. The limit was arbitrary. Read the Bill of Rights Act. Read the Bill of Rights Act. It says that a limit cannot be arbitrary. And in this case, the reason that it was arbitrary was that it did not take into account the seriousness of the offence, and that a person convicted of a minor offence simply because of timing lose the right to vote for 3 years, whereas someone convicted of a more serious offence may not lose the right to vote at all. And that was the unfairness of the situation. Now, I want to talk about the right to vote. People talk about the right to vote. Can I recast that a different way? Can I ask this House to think about the duty to vote? Not the right to vote. Let's recast it as a duty. We have an obligation under our law to be enrolled. We have an obligation under our law to be enrolled. Paul Quinn says with this bill that they shouldn't be allowed to go on the roll, and yet we require by law everyone else to be on the roll. So we say to somebody who's committed an offence, who happens to be in jail during the period of time where there is an election, you can't be on the electoral roll. And yet we require by law everyone else to be on the roll. So why the current law says that because it was changed. The current law says that because it was changed in 1993. And the way the current law was changed was to ensure that there could be a distinction made between those who were convicted of more serious offences, and the position was adopted of choosing the time frame of more than 3 years, which was a parliamentary term, and which actually solved the problem, drawing it into those who lose the right to vote because they go overseas for more than 3 years and haven't been back within that 3-year period. So actually the whole thing makes logical sense. Now, the only way that Paul Quinn can argue what he's arguing is that if he doesn't accept that there is somehow a moral duty to vote. And I don't think any person should stand or sit in this Parliament who doesn't believe that it's a duty to vote as opposed to merely a right, because I actually think a duty is far stronger than a right. And what the member is saying is that we should take them off the electoral roll, which means that if they are in jail at the point that they are seeking to a re-enrolment, they will come off the electoral roll. And I have to say, getting marginalised people in our society onto the electoral roll is one of the hardest things that we have to confront when we're trying to sign people up during the election campaign. And every member of this House will know how much resource we put into the Electoral Commission to make sure that people are on the roll in the lead-up to both a local body election, which is this year, and a general election, which is next year. And I think that people should think very carefully about what this bill really means, because it isn't about punishing people, it's actually about minimising the duty that goes with electing our members of Parliament and also electing our mayors and our city councillors and community board members and a regional council if we still had one in Christchurch. Mr. Speaker, I think that the fundamental issue here is that the individual member is using this as a dog whistle to those who want to see the government as having a tough stance on our prison population. So let's get tough on prisoners. Well, my view is that this law is completely out of date. It's out of time because it was considered in 1986 and it was implemented in an appropriate way by a national government in 1993. But what the point that I want to make is that the situation has actually become even stronger. So the explanatory note to this bill says that the Commission failed to consider prior convictions before a custodial sentence is imposed. So by the time you get to a custodial sentence, there are more serious offences that have been committed in the past. Well, this was before the days of home detention, which in my view makes an even stronger case for the Royal Commission's position. What this will say is that if an individual gets home detention, they're allowed to vote, but if they're in prison, they're not allowed to vote. The member's just given me the answer to that question. I can tell that member that there were 2 young men convicted in Christchurch last year of exactly the same offence. One lived in Fendleton with a very supportive family. One lived in Aranui with a very unsupportive family. And what happened? The one from Fendleton got home detention and the one from Aranui went to jail. So why should one get taken off the electoral roll and told he cannot be on the electoral roll when the other one from Fendleton is allowed to stay on the electoral roll? I think that the government have got this completely and utterly wrong, and what they need to actually work out that the underlying issue is much more important than this dog whistle political bill. What this bill will do is undermine what I believe every person in this country should accept, and that is that it's a duty to vote. It's not a right to vote, it's a duty to vote. It's a duty to be involved in our political system, whether it's local government or central government. And all this is doing is taking that 3 years, people who have been convicted to 3 years, who have to spend their time in jail as opposed to home detention, that the government wants to differentiate between those two. Well, I say shame on the members opposite. It is an absolute shame that this is allowed to come before this House and actually bring this House into disrepute by seeing this not as the important issue that we are entitled to see it as. It is a duty to vote, and I believe that this bill undermines that very duty.